1 minute ago, Ivanka Trump's name resurfaced inside the court record in a way that immediately altered the posture of the case, confirming suspicions that had been quietly circulating for weeks, and doing so at the exact moment Donald Trump chose to publicly attack the judge while the docket itself began moving faster. This was not a leak, not a speculative report, and not a political allegation. It was a procedural development, and those developments tend to carry more weight than any statement because they constrain what happens next. What makes this moment different from earlier mentions is not merely that Ivanka's name appeared again, but that it appeared in a context that aligns timing, sequence, and record structure more tightly than before. Courts are less concerned with names in isolation than with patterns over time. When a name reappears after efforts have been made to narrow involvement or distance responsibility, judges begin asking whether the earlier framing still holds. That is when suspicion moves from public discourse into judicial awareness. According to the latest docket activity, the reappearance occurred in connection with newly referenced records that were folded into the case through a supplemental process rather than a headline-grabbing filing. Supplemental records are not designed to shock. They are designed to clarify. They exist to refine timelines, correct gaps, and bring coherence to what might otherwise remain fragmented. When a name surfaces in that context, it signals that the court is being asked to look again, more closely, at how events fit together. The timing could not have been more consequential. Almost immediately after the docket reflected this update, Donald Trump launched a public attack on the judge, criticizing both the court and the pace at which the case was moving. From a political perspective, this is familiar ground. Trump has long relied on confrontation as a means of reframing pressure as persecution. From a legal perspective, however, attacking the judge while the docket is actively shifting is a risky move, because it draws attention to the very process the court is now asserting control over. Dockets do not move without cause. Courts accelerate when something changes in the perceived risk profile of a case. That risk does not require a finding of wrongdoing. It can arise from concerns about preservation, credibility, or the possibility that the record will become harder to manage if left unattended. When judges sense that risk, they respond by tightening timelines, narrowing disputes, and demanding clarity. The movement visible now suggests that the court believes delay would introduce more problems than it would solve. The records tied to this development are procedural by design. They reportedly involve authenticated materials, such as communication routing data, scheduling references, and transaction-related timestamps. This category of evidence carries particular weight because it is generated by systems rather than memory. Courts trust it not because it is dramatic, but because it establishes order. Once order is established, narratives must conform to it. When they do not, courts intervene to reconcile the gap. Ivanka Trump's name reappearing within this framework matters because it places her back into a sequence rather than leaving her adjacent to it. Courts are careful not to infer intent prematurely, but they are equally careful not to ignore recurring alignment. When names continue to surface as timelines are refined, judges are obligated to ask whether earlier representations were incomplete or whether new clarity has emerged. Either scenario justifies closer scrutiny. This is where the phrase "confirms suspicions" becomes procedurally relevant rather than rhetorically charged. Suspicion in a legal sense is not about belief, it is about unresolved questions. When the record begins to answer those questions in ways that reduce ambiguity, courts respond by asserting more control over the process. That appears to be the inflection point reached here. Trump's public attack on the judge adds a layer of institutional tension to an already delicate moment. Judges are accustomed to criticism, but they are also trained to separate noise from process. When faced with public pressure, courts rarely respond in kind. Instead, they respond structurally. They issue tighter orders, set firmer deadlines, and limit the scope of dispute. In that sense, attacking the judge while the docket is moving can accelerate the very constraints being criticized. Behind the scenes, this kind of development forces internal recalibration. When a timeline tightens and names reappear, everyone connected to the relevant events must ensure alignment. Legal teams, advisors, and anyone with knowledge of the underlying records must now consider how their accounts fit into the revised sequence. Small inconsistencies that once seemed harmless can become focal points once a court begins testing chronology rather than argument. This is why timeline collapses are often more destabilizing than substantive allegations. Allegations can be contested, timelines must be reconciled. Once a court locks in sequence, the range of acceptable explanations narrows. That narrowing is what creates pressure, not public outrage. The docket movement visible now suggests that the court is entering a management phase rather than a waiting phase. Judges move into this posture when they believe the integrity of the process requires it. Preservation obligations become more explicit. Certification requirements become more precise. Scope is defined more narrowly. These are not punitive steps. They are preventative ones designed to stabilize the record before disputes multiply. It is also important to understand what this moment does not represent. It does not represent a final determination. Courts distinguish sharply between procedural control and substantive conclusions. The reappearance of a name does not equal a finding. The acceleration of a docket does not equal a verdict. What it represents is a shift in how carefully the court intends to supervise what comes next. Trump's decision to frame this shift as an attack invites political interpretation, but the court's actions suggest a different logic. Judges are not reacting to rhetoric, they are reacting to structure. When records evolve in ways that tighten alignment, judges adjust their management style accordingly. That adjustment often feels sudden to the outside world, because it is based on internal thresholds rather than public expectation. As the case moves forward, the tension between public messaging and procedural discipline is likely to grow. Political statements are optimized for audiences. Filings are optimized for accuracy. When those priorities diverge, legal teams must choose which to privilege. Courts reward consistency, not volume. The reappearance of Ivanka Trump's name also widens the lens through which the case is viewed. If records suggest coordination or awareness across multiple points, the court must consider whether the scope of inquiry remains appropriate. That does not mean expansion is inevitable. It means expansion becomes possible. Judges prefer to avoid that possibility unless necessary, which is why they often act early to resolve ambiguity. This moment also carries implications beyond the immediate parties. High-profile cases influence how courts manage similar disputes in the future. When judges demonstrate a willingness to assert control quickly, it sets a reference point. Future litigants adjust their expectations accordingly. That is how procedural norms evolve, not through announcements, but through patterns. As of now, the docket reflects movement, the record reflects tighter alignment, and the court's posture reflects concern about maintaining clarity. Trump's attack on the judge has added political heat, but it has not altered the procedural calculus. If anything, it has highlighted the contrast between external pressure and internal discipline. What happens next will be determined less by what is said and more by what is filed. Certifications will matter, preservation will matter, consistency across submissions will matter. Courts measure credibility not by tone, but by alignment over time. In moments like this, the temptation is to focus on personalities. That is understandable, but it misses the point. The real story is structural. A name has reappeared in a context that tightens sequence. The docket has responded by moving. The judge is asserting control. Those elements together signal a transition from narrative management to process enforcement. Once that transition occurs, the room for maneuvering shrinks. Parties can still argue relevance and scope, but they cannot argue sequence away. The court's job is to ensure that whatever the outcome, it rests on a record that makes sense. That job becomes harder when timelines fracture, which is why judges intervene when they do. Right now, the case sits at that junction. Ivanka Trump's name is back in the record in a way that matters procedurally. Donald Trump has chosen confrontation as his response. The docket is no longer static. The next filings will determine whether this phase stabilizes or intensifies. When courts move like this, they do so quietly. There are no dramatic announcements, no sweeping declarations. There is only motion. and motion in a docket is often the clearest signal that the legal terrain has changed. That is where things stand, not at an endpoint, but at a threshold where suspicion has been translated into procedural focus, where rhetoric has collided with structure, and where the case has entered a stage defined less by what is claimed and more by what the record can support in sequence.